Hi, my name is Jamahl Kersey and I'm a criminal defense attorney in San Diego, California. And in this video, I'll be explaining what can be done when you're arrested for domestic violence charges and the alleged victim wants the case dismissed. This is one of the most common questions I get as a criminal defense attorney. A guy gets arrested for domestic violence. After things calm down, the couple wants to patch things up. The girlfriend doesn't want to move forward with the case. So they have the typical questions. Can my girlfriend decide not to press charges? Can she talk to the DA? Can she talk to the judge? What can I do? How can I get this case dismissed? So let's picture a situation where neighbors hear Jack and Jill yelling. They call 911 and the cops show up. When the police arrive at the apartment, they're going to take statements and they're likely going to take pictures. In this situation, they are looking to find out a couple of things. Who was the initial aggressor and who was the dominant aggressor? The initial aggressor is the person who escalated the situation from mere words or a verbal altercation up to a physical altercation, whether that's a slap, a push, a punch, or throwing an object. The dominant aggressor is the person who got the best of the other person. The officers determine who was the dominant aggressor both by what they see visually and what they hear via the statements. Once the police determine who was the dominant aggressor, that person is generally going to be the one who's arrested and taken to jail. With domestic violence, a lot of times I have clients who have never seen the inside of a courtroom, never been charged with a crime. They're facing domestic violence charges and they're really freaking out. They're nervous about ending up in jail, possibly losing their job, and having a conviction on their record. However, the victim does not want the case to go forward. The couple really just wants to put the situation behind them and move on with their lives. One of the biggest misconceptions is that the alleged victim is the one who presses charges. This is not true. Here in California, it is the people of the state of California, by way of the district attorney, that charges files against an accused, not an alleged victim. When the police are interviewing the alleged victim, they will ask, do you desire prosecution and are you willing to cooperate with the court process? The answers to these questions can hold some weight in terms of whether the prosecutor ultimately decides to file charges or not. However, I've seen plenty of cases over the years where the alleged victim did not desire prosecution and the DA's office files charges anyway. I've also seen cases where the alleged victim desired prosecution and the DA, usually because there was insufficient evidence to move forward, declined to file charges. Whether charges are going to be filed or not is ultimately within the hands of the DA. Once the police are done with their investigation, they turn their file over to the DA's office. There's an issuing DA who goes through all the evidence to determine whether they believe they can prove a domestic violence charge beyond a reasonable doubt. If they believe they can, then they're going to proceed and file charges. The reality is, there are situations where there really is serious violence in the household and the victim is in legitimate fear for their safety. However, they may not want to anger their boyfriend or husband by continuing with the case, or they still love the person and don't want them to be prosecuted. So sometimes women will take back what they originally reported and say nothing actually happened. This is also known as recanting, or they will refuse to cooperate with the prosecutor to protect their man. Depending on the circumstances, sometimes an alleged victim will want to have the case dismissed and the DA's office will move forward with charges anyway, acting in what they believe to be the individual and the public's best interest. This is one of the reasons why it's not a good idea for the alleged victim to contact the DA herself to try and get a case dismissed. The judge is not going to listen to a statement or read a letter from the alleged victim saying she wants the case dismissed. Unfortunately, that's just not how the system works. Again, it is the prosecutorial agency that has the power to dismiss charges after they've been filed. If a client presents this situation or something similar, I'll look to see if there's a chance we can either convince the DA to not file charges, or if the case has already been filed, attempt to get that case dismissed. I'll have my investigator take the statement of the alleged victim so I can get a rundown of the facts without the influence of the police. I'm looking to see if there's evidence that would prove my client is not guilty or would raise some serious questions as to whether the prosecutor would ultimately be able to prove my client's guilt beyond a reasonable doubt. I may also get together mitigating information such as my client's educational background, work history, lack of criminal history, any good things I can say about them. Do they go to church? Have they done any community service? Are they otherwise active in the community? Additionally, Additionally, support letters from employers, teachers, friends, and family are oftentimes persuasive in demonstrating good character. We would then turn the packet over to the DA's office, but the most crucial part of the packet would be the alleged victim's statement. The statement would ideally either negate the information that's in the police report or add important facts, which could then lead to a dismissal. So there you have some insight on my approach to DV cases. If you're facing charges, you're in the state of California, and you're interested in seeking a consultation, feel free to give us a call at 619-399-3662. As always, thanks so much for watching. We'll see you next time. Peace.